Good day, everyone. Thank you for taking the time to join us and learn about best legal practices in owning and operating rental properties. This presentation, we're going to cover how to list, sell, and close a tenanted property during COVID-19. More specifically, the N12 and the cash for keys. If you already haven't done so, please head over to our social media, like us, follow us. We tend to always give our materials away for free on Facebook and Instagram. There's a QR code at the bottom left corner of this presentation slide. If you scan it with your smartphone, you will automatically add us into your contacts. Feel free to check out our website. And if you ever come across a landlord and tenancy matter that you feel the need that you want us to help you clarify something, please reach out. So let's get started. So a brief introduction about myself. My path started in real estate in and around 2004, 2005, where I obtained my license and I started acquiring landlord and investor clients who purchased small to medium-sized apartment buildings, commercial plazas, but they didn't want to tend to the day-to-day operations. So alongside my husband, Rob, we started a property management company, and that was Stonegate Property Management, where this acted as an umbrella to basically manage the day-to-day operations of these properties. And through that path, I would often end up going to the landlord and tenant board. And 9 times out of 10, my matters would get dismissed because I was not a licensed paralegal or a lawyer. So because I love school so much, I went back to school, I obtained my paralegal license, and then my business totally just took a shift in the way that now all our legal firm does is that we provide support to landlords, investors, and realtors. So let's get started. For the purpose of this presentation, everything we discuss is for information only and not to be taken as legal advice. So the top 3 questions we get asked all the time are the following. I get phone calls saying, Bita, can we evict a tenant to sell a property? Or Bita, the tenant isn't allowing for showings. Can we kick them out? Or the landlord's lease is coming to an end. Can we give the tenant notice to move out? And the answer to all these 3 questions is no. All tenants have what we call security of tenure. And what that means is that tenants are entitled to occupy the rental unit or rental property after the initial term is specified in the lease agreement ends. The tenancy relationship will now go on a month-to-month. Instead of being a 1-year fixed term tenancy, it's now a month-to-month tenancy relationship. You see, a tenancy can only be terminated in one of 3 ways, okay? So number 1, if the tenant decides to leave and gives notice. Number 2, if the landlord and tenant mutually agree to end the tenancy, and that's by way of an N11. We're going to discuss that through the presentation. And number 3, the landlord gives notice for any reason under the act and the tenant moves out, or if not, the landlord can pursue an eviction through the landlord and tenant board and apply for an order. So one of 3 ways that tenancy can only be terminated. Let's talk about vacant possession. So can a seller landlord guarantee vacant possession when a property is sold? So I want to be very clear because we come from a real estate background. There is no such guarantee to vacant possession. There's no such thing. It doesn't exist because all parties to the transaction are relying on the tenant in order for them to move out, in order for the transaction to close. More specifically, clause number 2, which is the closing date clause in the agreement of purchase and sale. This is located on the front page of the agreement of purchase and sale. The last sentence, it has a vacant possession clause innately built into the offer. And this is the vacant possession sentence, okay? Upon completion, vacant possession of the property shall be given to the buyer unless otherwise provided for in this agreement. Again, this vacant possession clause is innately built into the agreement of purchase and sale. So therefore, a clause in Schedule A is not really required unless it is specifically stated otherwise. So for example, unless it states that the buyer agrees to assume the existing tenancy. You have to be really careful when you're signing agreements of purchase and sale, when you're purchasing tenanted properties. So what happens when a property is sold? So let's say you went out there, you purchased a property, it's tenanted. What happens? Time is now of the essence. So I always inform my realtors that moving forward, you have two options. Okay. Option number one is that the legal representative or the landlord, not the realtor. So realtors cannot get involved with serving legal documents. This is what the N12 looks like. Okay. The N12 is a notice to end the tenancy for the landlord or purchaser's own use. The screenshot on the left is the first page of the N12, and the screenshot on the right is the second page of N12. So just by looking at it on its face, you're probably thinking, hey, how hard is this? All I have to do is fill in a few boxes. Well, the reason why I don't want realtors to get involved with this is that because you guys don't know the consequences or requirements that come along with serving legal documents. So let's backtrack a little. So when does an N12 serve? The N12 can be served for the landlord's own use. That's if the landlord or their immediate family member, being their child or caregiver, requires the property for their own personal occupation for at least 1 year. Okay, it's very important that they reside in the property for 1 year, or for the purpose of this presentation for the purchaser's own use. If the landlord has signed an agreement of purchase and sale, if the property contains 3 units or less, and the purchaser or the purchaser's immediate family member, child, parent, or caregiver require possession of the property for residential occupation for at least 1 year. You see, a new purchaser cannot issue this notice if the landlord is a corporation or for members of their extended family, brother, sister, aunt, or uncle. Just keep that in mind when you're debating on how to end the tenancy uh, for a property that's tenanted. The N12 has a good faith requirement. So let's talk about good faith. Good faith is having what? It's having the genuine intent to occupy the rental unit for residential purposes. Landlords should not serve the N12 to a tenant because they are experiencing problems with the tenant. If the tenant has blocked them on WhatsApp, if the tenant is not answering their WeChat, if the tenant is not responding their Facebook messages, landlords cannot use an N12 in order to, as a loophole in order to end the tenancy or get rid of a tenant, because tenants have rights. One of the rights that a tenant has is that a tenant can file a T5 bad faith application against a former landlord for bad faith within 12 months of the date that they moved out. Okay, this is very important. The good faith has to be there when serving an N12 notice. How can you serve a tenant? So I have to say, I really love the real estate industry. And that's because the real estate industry has really evolved with technology. You guys are using smartphones, you're just scanning documents, you're using e-signature tools to sign them. Well, the wheels of justice are spinning very, very slowly. And what that means is that landlords must serve their tenants in accordance to the rules of the Landlord and Tenant Board. They must fill out a certificate of service and file the notice with the certificate of service for a hearing. A landlord may serve their tenants in one of the following ways. Number one, by handing the document to the tenant. Number two, handing it to another adult in the rental unit. Number three, placing it in the tenant's mailbox or where mail is usually delivered. Number four, sliding the document under the door or through a mail slot. Number five, faxing it to the tenant's place of business or residence. Or number six, courier, registered mail, or express post. If you're serving a notice via mail, registered mail, or express post, you must add 5 additional days to the date of termination. Again, I don't want you guys getting involved with serving legal documents. What is the test of bad faith? So how does, we talked about good faith and that there needs to be a genuine intent. What about bad faith? How do we know that the landlord, or how can we test that the landlord actually has served this document in bad faith? Well, at the Landlord and Tenant Board, adjudicators use a 3-part test to determine whether or not the N12 was served on bad faith. And the 3-part test is as follows. They will ask, did the tenant rely on the N12 in order to move out of the property? Number 2, is there an advertisement of the rental property? Is there an MLS listing? Is there a Kijiji ad? And number 3 is the most important part. Did the person who was supposed to move into the unit actually move in? This is the 3-part test, guys. It doesn't matter. There are no excuses because tenants can request the remedies, certain remedies for the board to order. And the following remedies are what a tenant can request on a bad faith application. So they can request a rent abatement, the difference in rent between the former unit and the new unit times 12 months, in order to pay a fine into the board, moving costs, any out-of-pocket expenses that the tenant has incurred up to $50,000, and basically any other order that the board finds appropriate. This is why it's so important that the N12 be served in good faith. Now, one of the requirements of the N12, of course, is compensation. Per section 48(1) of the Residential Tenancies Act, compensation must be paid before the termination date in the amount equivalent to 1 month's rent. A declaration or an affidavit must be submitted to the Landlord and Tenant Board. And per the new Bill 184, landlords must disclose in their declaration or affidavit of any previous notices of termination served to the tenant. Again, this is why I don't want realtors serving these documents, because you don't know the requirements to the notice and to the application. Now, even on an N12, the N12 is just a notice. It doesn't have any enforcement behind it, because on the second page of the N12, if you can see, that's a screenshot, the third bolded box from the left down, it says, it asks a question to the tenant. What if you disagree with the notice? And to the right, it says you do not have to move out if you disagree with what the landlord has put in the notice. And that means if the tenant wishes to dispute the notice, they are not obligated to move out of the rental unit and can remain in the unit until a hearing date is set. So what does that mean for someone who sold their property? This means that your closing date is going to be affected, and that if you don't close as a result of the tenant not moving out, you're going to be in breach of contract, which means you're going to have to pay a penalty to keep that buyer around so that you can provide vacant possession. Now, if the tenant decides to leave earlier, great. Then the termination date indicated in the N12, then the landlord must provide a refund of any extra monies that they hold in their possession, as well as the 1 month's rent compensation. So let's talk about the hearing, because the N12 must be filed with the Landlord and Tenant Board along with the certificate of service. Whomever the landlord is the landlord or their legal representative, whomever is going to be filing with the Landlord and Tenant Board, must provide documentation to support the N12. And what are these documentations? So if you sold your property and the new purchaser requires possession, you need an agreement of purchase and sale, a doctor's note if a caregiver is required, affidavits, declaration, any other documents requested by the board. How do we cancel an N12? This is very important, because what if you genuinely give a notice of N12, or you or the new purchaser were wanting to or looking to move in, and then what happened is your life took an unexpected turn? There is no set way to cancel or redact an N12. It's not a redactable notice. Landlords must make certain that the person whom they've set to move into the rental unit is 1,000% committed before serving the N12. So things like, excuses like the person changed their mind, or my life took an unexpected turn, none of these are going to fly with the board. Okay. If the tenant has signed another lease and has moved out or is moving out, compensation still must be paid. And if the tenant files an application for bad faith, again, they can sue the landlord for up to $50,000. Let's talk about errors. All legal notices must be free from any and all errors, no matter how minor. You must cross your T's, you must dot your I's, because if there's any error in the application, one thing is guaranteed, is that the application will be dismissed and the process must be restarted. And when I refer to errors, I'm referring to names, dates, calculations, address of the rental property, you forgot to put basement apartment, any minor error. Okay, your application will get dismissed. Let's talk about the delays, because the delays are very important. So pre-COVID, the average amount of time it took to receive a notice of hearing was about 4 to 5 months. As you're all aware, the board closed down between March 16, 2020, and they started holding hearings for landlord applications on August 1st, 2020. During that period from March to August, they've incurred about 80,000 applications. And 90% of those applications are landlord applications. which means what? Which means currently the average amount of time to receive a notice of hearing is about 9 to 12 months. So you're probably thinking, if the N12 is the first option and it's going to take some time to get to the board, and then it's going to cost the seller landlord money if the tenant doesn't leave to pay a penalty to the buyer, what's the alternative? So let's talk about the alternative. The alternative is what I refer to as a cash for keys. And a cash for keys is exactly what I call it. And it's an enticing offer, usually in and around 5 to 10,000, but our firm has also done many cash for keys for 20, 30, 40, 70, 100, 150,000 in order to facilitate a termination of tenancy. A cash for keys is not a DIY. It's not something that you would attempt to do it at home because you don't know what is involved and what should be in your agreement. Hire a legal representative that is well versed with the Residential Tenancies Act and knows how to facilitate a cash for keys. That legal representative will negotiate terms directly with the tenant. They will draft a consent agreement and an N11. Remember, the N11 is what we spoke about, which is kind of like a mutual release. Okay, it's the agreement to mutually end the tenancy. The N11 is a very powerful agreement. I call it the Incredible Hulk because once the N11 is signed by the tenant is basically giving up their rights to the tenancy. The N11 and the consent agreement should be filed with the landlord and tenant board for an ex parte order. And the beauty of an ex parte order, which is just basically a fancy legal term for an immediate eviction order without a hearing. You're bypassing the time it will take to get to the board. So you're bypassing the 9, 10, 11, 12 months. The timing for a cash for keys is roughly anywhere from 30, 60 to 90 days maximum in order to receive an order from the board. And your legal representative will usually arrange for the keys to be picked up. A cash for keys can be simple or it can be very complicated. So this is why I say realtors, property managers, please do not get involved with facilitating a cash for keys. All right, so we're almost at the end of the presentation. This is the Landlord Mastery. Head over to www.landlordmastery.ca or click on the link below. This is a free guide that you can download. It gives you access to our Google Drive where Rob actually updates regularly. And the Google Drive is full of scripts, forms, other agreements like the parking agreement or the air conditioning agreement, a notice of entry, how to prepare a property for lease. It has the Ontario Standard lease agreement that's effective March 2021. It's a great guide. Rob and I have developed it. We use it for our own rental properties. We give it away. We've always given it away. So feel free to download that guide. It's a guide. It's a great reference. So we've come to the end of the presentation. Thank you for listening. Again, if you ever have any questions, feel free to reach out, info@stonegate.legalservices.ca. Email is the best form of communication to get a hold of us. Head over to our social media, like us, follow us on Facebook and Instagram. Scan that QR code as a contact, and feel free to reach out if you ever have any questions. Until next time, bye for now.